and welcome to this episode of Retinal Realities, brought to you by Roth Products and hosted today by Karen and Claudette. Our special guest today is Sonya Lee Mahabeer, who is here to tell us about a much neglected area, wills. But first, let me tell you a little bit about Sonya. She is an admitted attorney who is passionate about ethics, human rights, commercial law, including financial planning law, ESG and legal education. She is a member of Retina South Africa and is involved in both the governance and youth subcommittees. That certainly keeps her busy. In this podcast, Sonya will share some insights which aim to create awareness about drafting a will and testament. She also discusses the objectives of a will and some legislative requirements. Sonya believes that a will is the most important document that one would ever sign during their lifetime and encourages everyone to use this week to get legal advice and ensure that your will is drafted and regularly reviewed. Thank you, Sonya. We're going to hand straight over to you.
Thank you, Karen, for that warm introduction. As usual, it's an honor to be part of this dynamic NPO, Retina South Africa, and I'm excited to engage today on a topical subject relating to wills, which is a crucial estate planning tool. But before I get started and we move along to the podcast, I would just like to state that the content of this discussion will not constitute legal advice, and the purpose of this podcast is purely informational. I urge all listeners to consult with their legal practitioner when drafting a will. So thank you for that. I'm ready to get started.
So Sonya, tell us a little bit about this event, National Wills Week. And what is the significance?
So National Wills Week is an initiative taken by the Law Society of South Africa. It's an annual week set aside to create awareness and education for citizens about the need to have a last will and testament. As you are aware, this year, National Wills Week runs from the 11th to the 15th of September. And the current stats within South Africa is that there are about 70% of people who do not have wills. So therefore, we should all be an instrument in creating awareness. The Law Society rightly states that by making a will, you're ensuring your assets are disposed of in accordance with your wishes after your death. And this is connected to the concept of freedom of testation. Also, to add on to that, I personally believe it's an appropriate time to reflect on our lives and the reality of death that awaits each and every one of us. It's a great time to start thinking about legacies, our wishes, donating to charitable organizations, and also ensuring our loved ones are catered for when we're no longer around to provide for them. So I would say that's the importance of this week.
Thank you so much, Sonya. And I'm amazed that you say a full 70% of people in this country don't have a will. What practically then happens when there's an instance where one does not have a valid will when they do pass away?
So, Karen, I think there's a lot. It's a wide topic, but I'll keep it brief. The reality is that death comes with a heavy administrative burden for those you leave behind. Reporting a death is a lengthy process governed by the administration of the Estates Act. For purposes of our discussion, when one passes away without having a valid will, the provisions and rules set out in the Interstate Succession Act apply. There are essentially various scenarios set out and rules that are applicable. So to make it practical, I'm going to give you an example. Let's, for instance, say a person dies without any descendants. However, they do have a surviving spouse. In this case, the rules state that the surviving spouse will inherit the entire estate. So a situation like this leaves room for conflict with others who may have been supported by the deceased. So that's the first instance when you die without a will. On the other hand, when the deceased dies with a valid will, the Wills Act applies. It is also important for us to make our loved ones or our executive aware of where our will is. So this ensures that upon our death, it's easily accessible and people are aware that when they're processing the process through the Master of the High Court, that your will can go along with.
Wow, Sonya, that sounds very complicated. And the legal jargon can be very complex and unfamiliar to most. Fortunately, I have a will, but don't ask me to explain it. So can you perhaps outline the significant terms and role players when exploring this subject a little bit further?
Yes, sure, Claude. Let me try and explain a few basic terms. So a testator is a person who's a male and is competent to sign their will. A testatrix is a person of the female gender competent to make a will. Very importantly, we're all aware that a will needs to be witnessed. So we call our witness a competent witness. This means a person who is 14 years or older of age, and they're actually able to give evidence in a court of law. So that's your competent witness. You get an executor or an executrix. These are people who are responsible for the administration and winding up of the deceased estate. Very importantly on this term, should someone be appointed as an executor, the male, or executrix, the female, they cannot benefit from the will that they're actually administrating. And then another term I think that's important or noteworthy is sign. So this word bears the ordinary meaning, but furthermore, in terms of the Wills Act, the word sign also includes making a mark, and I'll get to that a little later perhaps, making a mark or including a thumbprint or an initial. So those are the basic terms when looking at a will.
Wow, that certainly seems to entail quite a lot. And you've just had me thinking now, a lot of people don't really have much to leave behind. Does everybody need to have a will?
So in my opinion, yes, everyone needs to have a will because it's one of the most important documents that one would ever sign. However, because a will is a legal document, there's a piece of legislation that governs it, and there are specific requirements in there. So only a person who is 16 years of age or older may draft and sign their will. And the intention behind this, Karen, is to ensure that the person drafting the will is mentally capable of appreciating the effect of their actions. Because obviously a will has implications and consequences. So it's very important that someone's at the age of maturity when they're doing this.
Okay, Sonya, so now let's take it down to the very basic level. Here I am, I don't have a lot of money or possessions. How would I actually do a will? What are the highlights and the requirements of a valid will?
Okay, so firstly, your will's got to be in writing. That's a requirement by law. I would also think that it's very important to be specific about people you're mentioning in the will. So be it beneficiaries or heirs or even your spouse, it's very important to put in their full name and their ID number. I think that's an important one. A will also needs to be extremely clear and unambiguous. And this is the fundamental concept of freedom of testation, which is embraced in our South African law. Your will can incorporate many things about perhaps a special needs child and their requirement or your instruction on cremation. So it's very important to be precise, clear, leave no room for interpretation. A very important aspect as well is the witnessing and signing of a will. So the will must be signed by the testator if he's a male and testatrix if she's a female. And this must be done in the presence of 2 or more competent witnesses. At this stage, the witnesses also need to attest and sign the will. If the will is more than 1 page, each page other than the last page should also be signed by the testator. And this is the very basic process, Claudette. The process gets a little more complicated if, for instance, one signs with a mark or a different instrument. And I also recommend, even though this is not a legislative requirement, that when you draft a will, you date the document. This will help establish the most recent document. So I think those are just the basics. I'd also like to highlight that a will can get more complicated and different requirements apply. For example, we need to also have cognizance that one's marital regime impacts how the estate is distributed. So very high level, that would be the basic formalities of a will.
That's so interesting. You've certainly outlined it very clearly for us. But now you've got me thinking, because as you know, we deal with people with visual impairment. What happens in a situation where someone is unable to sign their own will, perhaps because of visual impairment or any other physical impairment?
I think that's a very good question, Karen. And the Wills Act does make provision for the testator to sign, like I said, using a mark or a thumbprint. If that also isn't possible, the testator may appoint someone else to sign the will on his or her behalf. In this situation, there's additional legal requirements, and the services of a commissioner of oaths is also required. So it's a little more complex. And another tool, I would say, is to have a trusted person around, or even a curator, to help the person who is visually impaired to manage the process and ensure that everything that their wishes are clearly stipulated.
Wow, Sonya. So I think simplistically, people just need a clear document that is signed and dated and states their wishes. But I think every individual requires actually a customized document to dictate their wishes clearly. So I assume that drafting a will and testament can become rather complicated if you, as you say, have more than one marriage, have more than one child or heir, and some assets. So who is best placed to assist people draft a will, knowing that if you get a lawyer, it might cost you a lot of money?
I do agree that it can be a complicated affair, and therefore an expert should be involved. Claude, I do understand that sometimes there's expenses involved, but I do think that this is something worthwhile paying a bit of money for and getting the correct services. Sometimes the creation of the will can also lead to other testamentary instruments, and one should also bear in mind tax implications, and hence a specialist should be involved. So it's best to consult with a legal practitioner, even a trust company or a fiduciary specialist. Sometimes your bank also can help, or your insurance company. However, in light of National Wills Week, it is also a good idea to look up on the Law Society's website and search for participating law firms that may be offering a free will drafting service. That's what this week is actually about, Claudette.
That's great news. Thank you, Sonya.
Yes, very, very interesting. And you've certainly given us some really good guidelines and very important stuff to think about. What parting message do you have for everyone listening to our podcast today, Sonya?
Well, I would say a will is a very powerful way to leave a lasting impact and provide security for your family and beneficiaries. This is something everyone needs to prioritize because death is an inevitable part of our journey. I personally believe that having your will drafted and regularly reviewed makes life easier for your family during the time of grief. And hence, I think we should all use this week to think about it and action those thoughts.
That's such sensible advice, Sonya. Thank you so much. And thank you for coming on this morning to give us this, in your level-headed, normal, simplistic and to the point way. We really appreciate it. And we'd like once again to thank our sponsors, Roche Products, for sponsoring this wonderful series of Retinal Realities. And if you have a story to tell, please contact Retina South Africa. Thank you, Karen. Thank you, Sonya Lee.
Thank you.
You're welcome, Chloe. Thank you.